ladies, my lords. I was on the genuine connection. We've done time-lapse and then investigatory steps, and I was making the point, I think, as we ended before the short adjournment, that those are cumulative features.
Yes, you made that point. Yes.
148 of Janovich. Then convention values, that is the exception to the genuine connection test, and the description of that is dealt with in Janovich at 148 and following as well. And they identify a wholly exceptional case such as a war crime is the example that they give. So that was the Shilley, and then taking it slightly out of order, Janovich-Strasbourg intervention into the sequence. And between Shilley and Janovich, domestically, Magocki was decided. That's in Bundle 1, Tab 4, MS 3033. And the court, we submit, rejected the proposition that the Human Rights Act subjected, even post-Shilley, public authorities to a continuing obligation to investigate deaths which occurred prior to the HRA coming into force. It isn't a continuing obligation. See, for example, Lord Phillips at para 61. As he put it there, just because there's been a historic failure to comply with the procedural obligation imposed by Article 2, it does not follow that there is an obligation to satisfy that obligation now. And the reasoning of the court, in summary, was that applying the analysis under the HRA, which of course gives rise to different issues, to the issues considered in Strasbourg, where they're dealing with critical date dependent upon states signing up to the convention. Here we're dealing with the domestic transposition of ECHR rights through the HRA with its own issues, therefore, of interpretation. And the conclusion of the court in that case was that insofar as there is an obligation under Article 2 to investigate pre-HRA deaths, in other words, pre-October 2000 deaths, that is an obligation which arises by reason of current events. And in those circumstances, the court did not need to and did not address the question whether to overrule Macaire on the basis that the investigative obligation was now seen to be detachable rather than parasitic. Rather, the innovation was a much more limited one, and the court held that even though the HRA by and large was prospective in effect, subject to the limited exceptions in 22.4, nevertheless, the investigative obligation could arise because of current events and current processes, that is, post-October 2000 processes. So you can't just turn up and say, we'd like an inquiry after the Human Rights Act. You've got to identify some process which attracts a current obligation under the HRA. And in that case, they were able to do that because on the facts of Magocki, there was an inquest which was yet to take place, and the inquest was going to be the mechanism, see Lord Bingham and Middleton all those years ago, by which the United Kingdom satisfied the investigative obligation.
I was trying to find out what the argument was about in that case, because...
In Magocki?
Yes, I mean, there was a lot of talk about whether Article 2 applies and so on, but the substance of the point was really at paragraph 10 of Lord Phillips, I think, where representations as what should be covered
by the inquest. It was the Middleton-Jameson debate.
It wasn't a debate about the procedures which should be adopted or whether the tribunal sort of tribunal.
Well, no, I think it was Middleton-Jameson.
Scope, yeah.
So it was scope and outcome.
It was whether it had to be an Article 2 compliant inquest.
Exactly.
I understand that. What does that mean in practical terms?
Oh, well,
that's a
there's a
different.
lot of law about that.
I'm aware of that, but I try to catch up
yeah.
those of us who've been in all these cases.
There is a question as to the extent to which it truly makes a difference, because Jameson had the capacity to be broader. But anyway, at least in Middleton, that hiatus for Article 2 purposes was put to bed because it was made entirely clear that if you did have to satisfy the Article 2 investigative obligation, it had to cover not merely the immediate circumstance of the death, but the surrounding circumstances, lessons to be learned.
Yeah, but that's not an issue in this case. Everyone accepts this. That's not an issue in this case. So it throws no light on the issue that we have to deal with.
No. I mean, the question really in this case that McGaughey gives rise to is what sort of process and in what circumstances does an investigative duty in that current sense, I keep using the word current, but you know what I mean, post-HRA, in what circumstances does that arise where the death itself...
I understand that, but I mean, your submission is whatever it requires, De Silva satisfies it.
It is.
Yeah.
It is, and ultimately, therefore, this may be thought to be one of those cases where you can genuinely start...
I mean, it'd be very unfortunate if this case went off on the basis that it doesn't... this sort of argument. I mean,
right. Well, this is
we're
very
really concerned with the substance of whether
my Lord,
the inquiry fulfilled what it was needed to do.
With respect, that's an entirely fair point, and it's a fair point not least because some of these complex issues are going to be arising in other cases that are wending their weary way up to this court in the not too distant future. And as you're aware, on the current state of the Strasbourg and domestic case law, many roads lead to Rome. There are various ways in which the obligation can arise. It can arise through a current process, whatever that may be. If there isn't even a current process, but you have a pre-HRA death, you've got the vexed question as to whether or not to overrule McCare. If you do you then do mirror principle? Do you then...
I know, but yeah. I mean, you accept, the Secretary of State accepts that there had to be an effective inquiry, whatever that means, in the terms of designed to get at the truth. I mean, does it matter whether that's by virtue of Article 2?
But not for Article 2 purposes. We say that they'd already determined in Europe that what we had done was enough. That's why the issue is live.
That's what I thought your case was.
Right, but even if one gets to that stage, we certainly do say, but in the alternative, that De Silva was sufficient and more than sufficient. So I'm not going to spend long on this, but I just wanted to sketch where we were, if only to illustrate the complexities. But that is likely to be the big live issue. What circumstances are going to be enough to create the current process? But certainly McGaughey decided that if you had an outstanding inquest, and I would add, and if you hadn't already complied with Article 2 in other ways, then that inquest needed to do the business. That inquest needed to be sufficient. And that's Middleton Jameson. And so that's truly where we are in relation to McGaughey. And then in KU, there were questions as to precisely what the ratio of McGaughey had been. And the Court of Appeal, and indeed what on earth Janovich and Shilley meant. So all of those issues are out there and floating. The Court of Appeal concluded, but I'm not sure they necessarily determined all the limits of it, but they concluded, and their judgment is in Authorities 332, tab 32, 3878, they concluded in particular at paragraph 90 that the critical point about McGaughey was that there was an inquest. And it was that was going to be the mechanism for satisfaction of the Article 2 obligation, because there hadn't been any suggestion that the Article 2 obligation had already been met. The Supreme Court, I think it's fair to say, wasn't terribly interested in resolving that issue, or that set of issues, and was much more interested in the question, how would these principles work, even at the level of Strasbourg? And that's why there was all the debate around 1966 versus 1951 or 53. But to the extent that it did provide further elucidation in relation to McGaughey, and the majority expressly declined, I think, as Lord Neuberger points out expressly, because a majority view had not emerged, as it were, or a clear majority view had not emerged about the limits of all of these principles, they declined to engage in the question, is Macaire a dead letter as a result of the reasoning in Shilley? But on the inquest versus inquiry versus some other process issue, my learned friend entirely fairly points out that Lord Neuberger, in the bracketed section at the end of the paragraph, said inquest, and presumably the same logic would apply to inquiry. And with great respect, we can see the force of that. I mean, if you have a situation in which you haven't complied with your Article 2 investigative duties, and you then have an inquest, and that is sufficient to pull in the Article 2 investigative obligation, we submit that the same logic perfectly coherently can and probably should apply, as Lord Neuberger points out, to a full public inquiry if that's what you're using as your vehicle for compliance. There is, and it doesn't arise in this case perhaps, or doesn't arise very clearly in this case, there is a much more general question about whether or not you can simply turn up and say, well, there's some sort of process that's still going on after October 2000, ergo Article 2 in all its glory arises. But anyway, that's the nature of the issues and the progress of the case law to date. And so one has, in a nutshell, therefore, if I can summarise, two situations. You've got the position under ECHR and the international law issues of the kind considered in KU, and you've got the position under the HRA. At least in relation to the position under the HRA, the position has moved since Macaire. The questions are about how far. Plainly, it covers an inquest post-October 2000 in relation to death pre-October 2000, where there's been no Article 2 compliance already. And probably, as Lord Neuberger indicated in KU, the same reasoning would apply to inquiries in that situation. It's perhaps equally clear that the principle doesn't extend to create an obligation under Article 2, under the HRA, post-October 2000, just because there is a process of any description. That occurs after October 2000. And it also plainly doesn't apply if you are in a situation in which you have already taken the measures that would be required in the individual case to ensure compliance with Article 2. And it plainly doesn't apply in that situation because you've already complied. And the mere fact that you choose to examine issues further doesn't, as it were, recreate a whole set of new and repetitive Article 2 obligations. So it's got at the very least to be a live process, A, and B, a necessary part of satisfaction of Article 2. There is a much more difficult set of questions when you haven't had anything, as it were, post-October 2000, and the question then arises in relation to a death that occurred pre the Human Rights Act. This would truly raise the Macaire still binding issue. The question then arises, how does one go about determining, and in what circumstances is there, an investigative obligation, as it were, arising into the void in that situation, unlinked to a current required process. And at that stage, the likelihood is that the court would have to grapple with whether or not the mirror principle, as it was called in those cases, in other words, you simply drag the Janovich principles over and start trying to apply them directly into the HRA context, but using HRA introduction as the critical date. So you do it by analogue. You say, look at the Strasbourg jurisprudence that does the states before and the states after signature, or right of individual position or whatever, and then you drag that over and say, well, there's the analogue. Now the critical date is the HRA October 2000. When does it arise? And then you get into 10 years, genuine connection, and all of that. Just to make the position more interesting, there are the Brecknell principles, And the Brecknell principles, as you know, and I'll come back to them at the end, but the Brecknell principles, in a nutshell, are that an Article 2 investigative duty may revive in circumstances where new information, and there may be debate about the quality of that, but new information, I summarise, comes to light. So you suddenly get new information that bears on, for example, a police investigation. But of course, that's a very different species, as I'll explain in due course. But it's a very different species because what that doesn't, on any view, do is to reactivate everything. It creates, at most, a limited obligation to chase down the new allegation, the new evidence, the new information, to see whether it does indeed open up other investigative or prosecutorial opportunities. So it's a much more narrow obligation at base. Anyway, that's Brecknell and yet to come shortly. But so far as our facts here are concerned, the death was on the 2nd of February, sorry, the 12th of February 1989. HRA comes into force 2nd of October 2000. So prima facie, the death is before and a little over 11 years before the HRA comes into force. And we do not have a current inquest. There was, of course, the De Silva process, but that isn't and wasn't ever intended to be, as it were, the full-blown Article 2 inquest equivalent, for reasons which I'll explain when I come to the Committee of Ministers and the picture there. So we
Does it have to be in order to activate Article 2?
My submission is that it does.
Well, on whose ipsy dixit? On the government's saying we don't intend that this should be an Article 2 compliant inquiry?
No, certainly not. It's an issue for the court to determine. But the ipsy dixit that we rely upon is the reasoning in McGaughey, which is it's limited to those processes that are live and that would attract those procedural protections and that are intended to bind.
After the critical date?
Yes.
Yeah. Well, the De Silva review was conducted after the critical date.
It was.
Yes. And why should it be disqualified as an inquiry?
Because we've already complied.
But if the court were to conclude on its interpretation of what the Strasbourg court and what the Council of Ministers had done,
Right,
that there wasn't compliance, then the situation be?
Then it would.
It would have to comply.
Yeah.
Yeah.
That falls within my live and having to comply.
Yeah. Well,
That's how it works, the argument.
when does the compliance occur? Is it before the De Silva review? When do you say the government has complied with Article 2?
That's the Committee of Ministers argument, to which I'm going to come in due course. So we say it was complied with, as it were, by the combination of all the things that have preceded Stevens 3, but particularly Stevens 3 plus the DPP. I'm going to take you to that in a moment, but that's how the argument works, for good or ill.
Yes, that's your argument.
That's the argument. And I do emphasise that those two features, because otherwise, if you did any process, even if you'd already complied, it would be repetitive. But if you did any process after October 2000, you'd be in trouble, as it were. And that's a pretty serious law against perverse incentives. You know, you'd never do it. You're much better off not doing it. We're back into Brind and all that line of case law, but you're better off not doing it, because by doing it, you risk someone saying, well, you've done it now, and there it is. And you.
On the hypothesis that the government had already complied and it wasn't intending De Silva to be further compliance, I can see the argument. Yes.
But I mean, and there will be different. My Lord, I accept the implication of that, which is that there are going to be difficult issues around the nature of the processes that would or would not be enough if we're not in that situation. I entirely accept that. But I'm trying very hard to
Don't worry about
give Lord Carmouth a break and steer away from the rocks, if that's possible to be done. Yes. But I've made my submissions on the Janovich principles, so that if in truth the position that you're in is nothing after October 2000 of relevance, and you're then asking about the mirror principle and dragging ECHR into the HRA analysis by analogue, if that's what you're doing, then those principles do require that cumulative approach that I outlined, and it isn't enough simply to say, that was my quibble with Mr. Justice Stevens' analysis of my Lord Kerr's judgment in Magocki. It isn't enough to say simply, and I don't think Lord Kerr, in fairness, was saying that in Magocki anyway, it isn't enough to say simply where much of the investigation after the HRA has happened, that's it. Because you need the lapse of time and you need that. Lots of investigative steps. But that whole scenario only really arises, it might be thought, in circumstances where you've truly got the void, the procedural void after October 2000. So that's what we say about engagement. Compliance and the principles so far as compliance is concerned. Mr. Justice Stevens, paragraphs 25 and 26 in particular on those principles, citing various bits of Lord Roger in L that we respectfully submit correctly. I only highlight two features of the approach. The approach in Strasbourg terms is very well known to compliance with Article 2. But two features perhaps of those principles. Firstly, you don't need satisfaction in a single process. A number of different procedures can, in combination, meet the standard. And I get that, I don't invite you turned up now, but I get that from Amin, Lord Bingham in Amin, Bundle 3, tab 29, paragraph 20 sub 10 and 47. And I'll give you the MS page number in 1 second. 20 sub 10 is at MS 3790 and 47 is at 3800. From that same authority, I mean, the form can and will vary. The form of a compliant investigation can and will vary depending on the circumstances. There is, as Lord Bingham put it, no prescribed model. See paras 32 and 63. Resources are relevant. Family involvement can be relevant, but it's qualified like the publicity element or ingredient of compliance. It's qualified, the family involvement, to the extent necessary, and obviously it depends upon choices that families might make. And perhaps the best authority and the most authoritative treatment of those, as it were, qualified ingredients within this is in Lord Roger's judgment in the L case that I keep referring to. Can I invite you just to take that up? It's Authorities Volume 3 at tab 34. MS 4010 is the start of the authority. And the relevant paragraphs for present purposes are 75 and following. So really 75 to the end of that judgment is about 3.5 pages, but he there analyses particularly the flexibility that is permitted, the relevance of resources, the way in which, or the essential hallmarks of the investigative obligation. You see that from paragraph 78. The principal hallmark of an Article 2 compliant inquiry is that it is effective, and explaining what that meant in Ramsahai, the Grand Chamber. This is MS 4045. And the key guardian, as it were, of effectiveness is independence for obvious reasons. But then also dealing with, as you see from the first sentence of paragraph 80 by way of example. And you'll note his treatment there and in those paragraphs of the publicity. So he says at as a relative concept in essence, as you see at the beginning of paragraph 80, similarly because the investigator is independent, his investigation will be effective, so fulfill the requirements of Article 2, even though no part of it is conducted in public. Again, it depends on the particular circumstances, and cites Anguilova and Bulgaria.
Well, you're not suggesting, are you, that the requirement of effectiveness is fulfilled by the investigator being independent?
Not solely,
No.
but it's a key part.
Well, what are the other attributes of effectiveness?
Well, you get those from his citation from Ramsahai at 78. It's got to be effective for the purposes that are there set out. And you know the elements, the well-known elements of compliance. So sufficient involvement of family, sufficient publicity, and all the matters dealt with in Macaire and Jordan and all those cases.
Well, it must be capable of leading to the identification and punishment of those responsible.
As means rather than as a
Yeah.
result,
Yeah.
yes.
Nothing that's said by Lord Roger, as it were, cuts down the 4 or 5, I can't remember what we got up to, but 5 classic requirements for compliance with the investigation set out in Macaire, Jordan and all those cases. The wisdom in this judgment, if I may respectfully say so, is in the analysis of those qualified aspects, in particular the question of what publicity will be sufficient, and in particular recognising that in certain circumstances the process itself might for good reason not be public, but nevertheless it will be sufficient for some purposes if there's no publicity, and for other purposes if the result and the reasoning and all of that is made public thereafter. And that's really the stuff of the analysis at 80 and following.
There neither is nor can be any single off-the-peg model that is suitable for use in all cases.
Yeah.
I imagine you'd like us to pay particular attention to that.
I do. But I'm not seeking to, as it were, water down the requirement of effectiveness or dispute or disagree with or cite Lord Roger and L as being in any way dissonant with the usual requirements for compliance well established in the case law. It's just L considers and draws together some of those more relative ingredients and asks the question. So those, in essence, are the principles we respectfully submit, and we, again, respectfully agree with the conclusion that was reached by the Court of Appeal at paragraph 187, agreeing with the judgment and analysis of the learned judge in relation to compliance. And by compliance here, I mean compliance so that there was no need to establish a public inquiry of the 2005 Act kind. And the first reason for that, Committee of Ministers, if I can turn to the Committee of Ministers. As you know, the ECHR has mechanisms for deciding if the requisite measures have been taken to comply with a judgment of the court. And thus, in our case, whether the Article 2 investigative mechanism has been, or requirements have been ultimately satisfied, that's the question. And the position, so far as that is concerned, is that that responsibility under the Strasbourg system is, under Article 46 of the Convention itself, a responsibility conferred upon the Committee of Ministers. And my short submission is that this, therefore, provides a quite straightforward answer to the compliance question, on the basis that if it was good enough for the Committee of Ministers, it should be good enough for this court. You saw from the judgments below that the HRA, and come back to it, requires you to take the Committee of Ministers' decisions into account in the same way as you take the judgments of the court into account, Section 2. If the Strasbourg court wants later to reopen matters, well, so be it, it can do so. But unless and until it does so and produces a different outcome, this court, we respectfully submit, should proceed on the basis of Lord Rogers' well-known adage recited in Magochi at paragraph 93, Argenteratum locutum. So far as the Article 46 obligation is concerned, we've got a copy of the new version of Article 46. If you want it in hard, you can find it online. The relevant bit, I think it's changed, it's fair to say, and changed tolerably shortly after our March 2009 decision. But as it was then, in relevant part, it said the final judgment of the court shall be transmitted to the Committee of Ministers, which shall supervise its execution, old Article 46.2, and the changes that have been introduced in the new version are to confer expressly, as it were, on the Committee of Ministers a series of powers to refer back to the court if they're doubtful about the interpretation of the judgment, to refer back to the court a question as to whether or not the party has failed to comply with its obligations in the aftermath of a finding, and so on. But in essence, it's put into the hands of the Committee of Ministers, and the Committee of Ministers are described as being with the, on their own Council of Europe website, as being with the Parliamentary Assembly, quote, the guardian of the Council's fundamental values, and as monitors of Member States' compliance with their undertakings. So that's the function that they're performing.
Has there been any consideration in this country of what weight we should give to a decision of the Council? We've looked at how we deal with decisions.
You've done Pinnock and all that. I'm
Yeah.
not aware of anything so far as the Committee of Ministers is concerned. Just on the facts, so far as the Committee of Ministers is concerned, we've summarised them in our case at 115 to 128. The learned judge below, in direct answer to my Lord Carnwath's question, at least in the circumstance of this case, considers that they are to be taken into account and they are to be treated as authoritative unless inconsistent with some fundamental aspect. In other words,
So he took the same approach.
he took the same approach as Pinnock, effectively. That's 39 to 40 of his judgment. And conveniently, he sets out in the judgment at paragraphs 141 to 147, that's Mr. Justice Stevens 141 to 147, the history of their consideration. And you will see, can I just invite you to turn that up? I've been trying not to invite you to turn that up, but can I invite you to turn that up? MS 424 is Mr. Justice Stevens' para 147, which is the concluding paragraph of this little section. And you see what he there says. And we respectfully submit that's entirely correct for reasons which I'll show you in due course. I should have mentioned when setting out the legal structure of the Committee as Ministers, Article 46, I'm sure we can get a copy put on your desk if you want that, of the new one. But you've got that. But we quoted in our case at paragraph 118, MS 259. If I can take it from there, I don't think these are in the bundle, but do you see the rules of procedure? Drawing the distinction in effect between interim resolutions and final resolutions. And you see that final resolutions are issued so they can, the structure is under 16, they can do lots of interim resolutions that hold the thing over while they're investigating, calling for information, analysing it, they have a secretariat to support them and so on. And then the final resolution happens after having established that the high contracting party concerned has taken all the necessary measures to abide by the judgment, the terms of the friendly settlement will be executed. Committee of Ministers shall adopt a resolution concluding that its functions under 46, para 2, or Article 39 and so on of the Convention have been exercised. So that's the procedural and legal structure. And just to go to the chronology, you recall that I gave you the reference into Bundle 2, Appendix 2, to the judgment of the Strasbourg Court in Ms. Finucane's case. That is Appendix 2, MS 816. And again, I'm not going to invite you to read it all, but for present purposes, you will see that they found, in essence, that there had not been compliance with the Article 2 investigative obligations because each of the things that had occurred had their own slightly different Article 2 issues. So the police investigation is dealt with at 74, paras 74 to 75, sorry, 76, the inquests 77 and 78, Stevens' inquiries and so on. Stevens 3, I think, was still ongoing, if my dates are about right, and then the DPP, in particular the conclusion at paragraph 83, no reasons for the various decisions not to prosecute. And you see then that what had been asked for by the applicant was that the court should declare that the government, in response to those findings, should hold a fresh investigation into the death concerned. And you see that from paragraph 89 on MS 839. And the court declines to do so. And it declines to do so on the basis of the reasoning that you see in 89. If I can just invite you to cast an eye down that. MS 839, para 89. So that's what the Strasbourg court had done. There was then a great deal of correspondence between the parties, effectively, between the government and the family, to the Secretariat of the Committee of Ministers, in which, inter alia, public inquiry and all the issues around restriction notices and all of that was laid out entirely bare. The family's position was that that proposal would be incompatible and inadequate for the purpose of satisfying the Strasbourg judgment for all the reasons that you're well aware of. And the government's position was that that public inquiry was a separate political commitment and not a necessary part of the obligations under Article 46. And one gets that, for example, from MS 899. So you see the government's position set out under bold, italicised, number 5 just below halfway down the page, there's a reference to the Finucane case. And if you look at the final paragraph on that page, you'll see the position that the government have taken. Anyway, that set of submissions and correspondence and all of that swirled in the Committee of Ministers, and eventually the Secretariat made a recommendation, and that is in Appendix 3, MS 1283, 967 in the hard copy, so 1283 electronically. And you'll see, just to start with the recommendation of the Secretariat, that the case of Finucane begins, the consideration of it begins on MS 1282, about 3 lines into the page. You'll see number 6, and then in bold underlined, the case of Finucane. And then you'll see the heading underlined about 2 paragraphs down, just above paragraph 81, the response of the United Kingdom authorities to the Secretariat's request for further information. So bear that title in mind, just so you see that we're dealing here with the United Kingdom's position and not a conclusion at this stage of the Secretariat. And if you go over the page to paragraphs 99 to 101, those are setting out the position of the government in this correspondence and before the Committee of Ministers 1283. And then the Secretariat's assessment as the bold, italicised, underlined title above 128, para 128 on page 1285, and the MS numbering 969 on the hard. The Secretariat's assessment and conclusion run between 128 and 144. And you will see that under the heading Stevens 3, they analyse whether Stevens 3 alone would have been enough, and they conclude it wouldn't have been for various reasons. And for that reason, at 138, they propose to look at whether the above elements have been satisfied in relation to the subsequent procedures, and they then focus on the PPS's decision not to prosecute. And look at 140. The Secretariat therefore proposes to examine as to whether or not the decision of the PPS and the reasons given by the DPP-NI have satisfied the requirements of the judgment in the case of Finucane. I'm reading from para 140. And their conclusion is at 144. And that is then followed by the decision. So that was 19th of November 2008, that document, that consideration, that recommendation. And then the decision happens for roughly 4 months later, on the 17th of March 2009. In effect, after 6 years of keeping the thing open, not making a final resolution under Rule 17, but making interim resolutions under Rule 16. That's the process, as one sees from these documents. And then they get to a final resolution, as the judge recorded at 146, as we saw, and that is at MS 1289. And the relevant part is in the first third of the page, MS 129, hard copy 973.
Strongly encouraging the UK authorities to continue discussions in the terms of possible statutory inquiry, but closing the case, basically.
Exactly so, and referring to the possibility, so not insisting upon that as a precondition to satisfaction or compliance with the judgment of the court is the only proper and fair reading of that. If they were worried about that and they wanted to see its resolution, they could have done what they'd done repeatedly before, made an interim resolution. They didn't. They closed the case. And they did so on the basis that it was already satisfied because of the DPP's giving of reasons in the light of the information and investigation of Stevens 3. As I say, there's no doubt one can have an argument in future about whether it should be reopened or not, but that was a final resolution under Rule 17 and Article 46. And my submission is that one can and should, this court can and should follow that and take account of it. And it provides for sufficient compliance in those ways, i.e. pre-De Silva. That's the real punchline of all of this. Pre-De Silva, we'd already done enough under the Council of Europe framework to comply with Article 2 and to comply with the judgment of the European Court of Human Rights, whose judgments are overseen, the execution of whose judgments are overseen by the Committee of Ministers. So that's the short answer, and we respectfully submit, therefore, that the learned judge in the paragraph I took you to was entirely correct, and the Court of Appeal agreed on that front. The alternative submission is that even if that's not right, and even if we're in territory where Article 2 is engaged through all the convolutions of Magochi and Macaire and all the rest of it, that the various strands of investigative process that led up to and included De Silva are in combination sufficient. We've summarised in our case at paragraph 153, and they're considerably lesser, obviously, but we've, apart from Stevens 3 perhaps, for the reasons that we've just seen in combination with the DPP's reasons, but they are of a lesser order than De Silva in terms of work and volume and recognisability as satisfactory things. But 153 of our case summarises those other strands. So police investigation into the murder itself, February 89, the inquest, September 90, Stevens 1, September 89 to April 90, Stevens 2, 92 to 95, Stevens 3 in particular, and the DPP decision that you've seen. That's really key stage 1, if you will, that Stevens 3 DPP decision, which led, of course, to prosecutions. So Stevens 3 is key stage 1. The DPP decision with published reasons is key stage 2. You've seen all of those analysed. And then De Silva is key stage 3. And I've already dealt with that. If you get to that stage, we respectfully submit that if that isn't sufficient, we're all in trouble on what needs to be done to satisfy Article 2. So the submissions I make on the back of that, before coming briefly and finally to Brecknell, are these. There have been various investigations by the police and the authorities into the question whether charges should be brought against those directly responsible for the murder. The failings were identified, and some of the failings were identified by the European Court of Human Rights in that judgment we've just seen. However, they did lead to proceedings and convictions against direct perpetrators. For example, Mr. Barrett, the UDA member who pleaded guilty to his murder in 2004, and the colour sergeant of the UDR who stole the weapon used to kill him was convicted for his role in that theft. Both of those are set out as facts in Sir Desmond's report at in the executive summary at para 57. In relation to the charges and the investigation of the allegations of collusion, Stevens 3 was specifically set up to deal with that. It was thoroughly investigated by him, and material was provided directly fulfilling the primary aim of the investigative obligation to the DPP. And the DPP then published reasons which had the effect that we've seen in the Committee of Ministers, but are in any view highly relevant for the purpose of satisfaction of that obligation. And in any event, and thirdly, and if necessary, the further steps thereafter were sufficient to comply, and the De Silva report and process is obviously central to that. and I've made my submissions about it. My learned friend, when asked the question by my Lady Black, what do you say are the vices of the De Silva process? And I think he mentioned four. Firstly, he said it isn't a judicial figure. Our answer to that is that independence is the hallmark. CL, and a QC of Sir Desmond's eminence, plainly fulfills that criterion. Secondly, said my learned friend, it was not public. That is, it might be thought, a key part of the significance of Lord Rogers' reasoning in L. True it is that the process was not public in the way it would have been if it had been a 2005 Act inquiry, subject always, of course, to restriction notices. I'm going to reopen that issue. But that is not fatal to compliance, as we see from Lord Rogers' analysis. And the critical thing to bear in mind in relation to Sir Desmond's process and report are perhaps twofold in relation to publicity. One, there was, it might be thought, a proper and legitimate reason for conducting it outside the full glare of publicity, particularly given the sensitivities involved. And it might be thought that that was one of the things that contributed to both the speed of it and also its ability to get at the truth effectively. But secondly, and perhaps most importantly, the outcome of it, judged against the standards of accountability, the outcome of it was published. 500 pages, lots of documents declassified that had never seen the light of day. And that, on any view, we respectfully submit is sufficient to comply in our context with the requirement of publicity. Family involvement is a little more difficult for my learned friend in relation to Sir Desmond's process, precisely because of the correspondence that I took you to at the start of Bundle 5, of Appendix 5. They were offered, indeed, offered in terms wishing them to come. They were offered the opportunity to participate in that process. They could have participated in the process whilst reserving rights to say it wasn't enough. And they chose not to, and instead to ask the 15 questions that you saw in that letter. And then finally, and this is really the nub of it, I think, compulsion. But I've made my submissions in relation to compulsion, and I made them when I was going through Sir Desmond's report with you. It's evident that he did not feel the need for compulsion. There are many Article 2 inquiries that are set up without compulsion and operate perfectly effectively and perfectly satisfactorily. True it is that one can identify, no doubt, some cases in which compulsion is necessary to safeguard effectiveness, and Edwards is an example of that. But it isn't an immutable principle. It's an illustration of the principle of effectiveness in action. And for all of the reasons that I gave when introducing Sir Desmond's report to you, we respectfully submit that compulsion is not a vice in relation to the process that Sir Desmond followed. That leaves the Brecknell case and the Brecknell issues. My learned friend hardly touched on those in his submissions, but they are obviously live, and they were the subject of, in effect, the disagreement amongst the Court of Appeal and between the Court of Appeal and Mr. Justice Stevens. So there are issues surrounding it. I'll make three short points in relation to approach, if only because that may be of some importance in relation to other cases coming up. First, in principle, it is not every piece of new information that triggers this narrow obligation of consideration. The information must come to light, is the phrase, and it's a practical principle based on necessary investigative reaction by the authorities and utility. Secondly, that must mean that it becomes known to the investigating authorities, just some part of government or elsewhere buried in a cupboard. It's actually got to come to light in that sense. You'll appreciate that not all of these, or any of them really, are relevant in our situation, but for that purpose, see paragraph 70 of Brecknell. Thirdly, as Brecknell itself indicates, the information must have the realistic capacity to undermine earlier investigations or be capable of providing new evidential opportunities. Those are three short points about approach, and if that trigger is pulled, and I've made the point already so I can repeat it but only very shortly, if it is pulled, the obligation that is created is a narrow obligation of a prospective kind on the authorities to react appropriately to the new information. And of course, in our context, the punchline of that is that even if De Silva created a Brecknell-style further investigative obligation, the reference to new and significant information, it still doesn't get them to public inquiry. It gets them at most a review of lines of investigation and consideration of whether further opportunities are opened up. And that is the essence of what the learned judge decided, and he was right to do so if that stage of the analysis is reached. See, for that purpose, Mr. Justice Stevens 214 to 216. And the position, therefore, is that in relation to the judgments below, there was some disagreement amongst the Court of Appeal. It's important to understand where the agreement and agreement lies. There was some disagreement amongst the Court of Appeal members as to whether the principal was engaged by the publication of the De Silva report and its reference to new and significant information. And the reason for that was that Lord Justice Gillen, in a nutshell, concluded that it was difficult, if not impossible, to infer anything significant from the references in De Silva's report to new and significant information without knowing precisely what he was referring to. And the majority, the two junior members of the court on that occasion, concluded, no, there was the trigger at that point, and from that point on. I mean, it matters not terribly because, in truth, we know what has happened. And so that was the extent of the disagreement, but the extent of the agreement between the members of the Court of Appeal can be discerned from 190 to 198, and they were unanimous on that. And they were unanimous on, therefore, on the question whether, if the obligation, the Brecknell obligation was triggered, had it been complied with? Answer, they said yes. And they said yes, in particular, in the light of the two affidavits from Detective Superintendent Murphy that were then before the court. They're summarised in our case at 187, those two affidavits. If you want them in the raw, they're in Appendix 1 at MS 573 and 581, or in the hard copy numbering 276 and 284. And you now have, and this was the subject of the application to introduce new updating evidence before this court, a third affidavit, I think from the same gentleman, producing or providing an update to the court. But we respectfully submit that the upshot of all of that is that they've chased down what new and significant information Sir Desmond might have had in mind in that statement, and they then looked at it conscientiously and carefully to see whether it opened up new investigative opportunities. So if the obligation was triggered, it has been complied with, is the submission. that I make in relation to that.
But the third affidavit, that's not the letter.
That's not the letter, no. I don't, the letter is the very latest word, I think, that my learned friend handed up entirely without objection from me, so you should have the full picture. I think the third affidavit is, I only have it, I'm afraid, attached to the, there's an application form for admitting new evidence. It looks a bit like that, but it's a slim thing.
Yeah, got it, thank you. Thank you very much.
So really the letter that my learned friend handed up ought to be tucked into the back of that, if that makes sense, because it was his solicitors querying bits and pieces in a response from the PSNI on that.
Thank you very much.
I know, my lords, unless I can assist further, those are my submissions.
It appears not. Thank you very much, Sir James. Mr. McLaughlin? Yeah.
My ladies, my lords, if I could deal first of all with the submissions made by Sir James in relation to legitimate expectation. He identified 4 different stages in this process. Nothing arises from the first, the launch of the process. In relation to the second, the briefing to the Secretary of State, he said that this is about as careful and as comprehensive a briefing as I have ever seen, and there was a full-blown analysis. Now, with all due respect, my learned friend, that completely misses the point that we have tried to stress before this court. We have never complained about the lack of analysis by the officials. We complain about the lack of analysis by the Secretary of State. So no matter how comprehensive the briefing provided by the officials, the question is whether or not the Secretary of State has demonstrated, or even it has been demonstrated on behalf of the Secretary of State, that he conducted the appropriate public interest test, and there's nothing to indicate that he did. It was said by Sir James that there are sometimes recommendations in these briefings, and all that the Minister does is to sign off on one of them and indicate that he has approved the recommendation. If that had been the case here, then it would be possible, perhaps, to draw the inference that the Secretary of State approved a particular recommendation for the reasons supporting the recommendation. But there was no recommendation here in any of the briefings. The briefings, as the court will see on further examination, reflect a rehearsal of the reasons for and against in each category of each public interest factor, the 6 public interest factors that were identified at the start of the process. None was recommended in any case. So there are no recommendations here that have been adopted in some way by the Minister. The third stage then was exploring the options, and the court was referred to the record of the oral briefing in Appendix 4, hard copy 1262, which is MS 1582. And I would draw the court's attention to paragraph 4. Taking into account the family's position as set out in the written representation of 10.3, it was agreed that any non-statutory option would be excluded from further debate. Now, the significance of that is that after listening to and presumably considering, if we take this at face value, the full-blown analysis, the most comprehensive briefing ever provided to the Secretary of State, he came to the conclusion that the review option, the non-statutory review option, should be excluded from further debate. So that's the clearest evidence of the Secretary of State's assessment of the public interest factors. The review option wasn't an option. It was excluded from further debate. It's after that that we have the gap in the evidence that we referred to, namely the gap between this point in time when the Secretary of State, having considered the full-blown analysis, decides the review options out of the question, and then subsequently when we have the affidavit from Mr. Larmour saying the next we know is that the Secretary of State prefers the review option. Now, my learned friend, nimbly and with his usual skill, skipped over that gap without referring to it, but continued to refer simply to the briefings and the records of conclusions without pointing to any single piece of evidence, whether from an official or anyone else, explaining how the Minister came to that, the Secretary of State came to that new conclusion, and without explaining whether even the public interest factors, the analytical framework, as it's been described, of the 6 public interest factors played any part in the new and fresh determination, unspecified and unevidenced as it is. So we have, in the exploring of the options stage, evidence of a conclusion which is discarded, the conclusion being that the eventual decision isn't right and doesn't meet the public interest test. There's a reversal of the position, and that's not explained. And then we have to look at MS 1597. It's in Appendix 3. Hard copy 1277. Sorry, I've got the wrong reference. It's MS 1597, so that must be Appendix 4. Yes, it's Appendix 4. Hard copy 1277, MS 1597. After the Secretary of State has indicated that actually, contrary to his previous determination following the application of the public interest tests, he's decided he prefers the review model. And we have this paper then prepared by Mr. Threlfall at 1277, MS 1597, paragraph 1. Says, this note represents an alternative policy option in the Finucane case following the recent minister between the Minister of State, the Secretary of State and the Prime Minister on this issue. It is outlined, so this is taking account of this change of tack without reference to the public interest factors that Mr. Threlfall had spent time analysing. It is outlined to assist policy development and would need to be subject to a full public interest test. Now, that is, of course, a reference to the full public interest test that had previously been formulated, the 6 factors. That didn't happen. It never happened. At least, there is no evidence that it ever happened. At no further point in this process of exploring the options is there any evidence that anyone, including in particular the Secretary of State, examined to any extent the 6 factors. We simply have the next stage in the process, the meeting of ministers, at which it's decided the primary objective is finding the truth, and therefore we're going to adopt a process that couldn't, according to the officials, ever find the truth for the reasons that have already been identified. So the public interest test that Mr. Threlfall is trying to get his minister to perform is never performed. The only time it was performed the Secretary of State came up with a conclusion that the review option that was eventually adopted had to be discarded, couldn't be regarded as an option. So there's no compliance, assuming that there was some kind of genuine process here, which, as the court knows, we don't accept, there was never any compliance with it. So after reviewing those 4 different stages, my learned friend offered the conclusion that there was the fullest and most careful consideration. The nature of the decision was evident from the nature of the analysis seen. And the court has our point about that. It's not the Secretary of State's analysis, it's the officials' analysis. There was obviously reference subsequently to different factors such as cost and speed, but this was never done in the context of a proper analysis, taking all the factors into account, weighing the different factors, including the countervailing factors. My friend simply refers to the factors supporting the decision. There's no reference to the countervailing factors, which were supposed to be put into the mix, so to speak. Specifically, the gravity of this case, the fact of commitments made to have an inquiry in the first place, and the reasons for having an inquiry. And my friend suggests that all these matters were put into the mix in some general way. They fed into the eventual decision. That's not good enough, because this is not a case where the Minister was starting, the Secretary of State was starting with a clean palette, a blank canvas. He was supposed to be starting from a position where there was a commitment, where there was an obligation to discharge, a promise made, and then to identify whether, in the light of that, there were sufficiently compelling reasons to depart from it. Not just a question of weighing a number of factors, putting them all into the mix and coming up with a conclusion that he thinks is best. That's why Mr. Threlfall, among others, was insisting at different stages that there has to be a proper full interest test applied in accordance with the factors, the analytical framework identified at the start of the process. And that never happened. It's indicated that the reasons for the Minister's decision appear from, first of all, the Prime Minister's letter, so the letter in relation to the Prime Ministerial meeting in July. Again, we've taken the court to that. It doesn't reflect any analysis of the 6 factors. It reflects an assortment of reasons which don't constitute an analysis in accordance with the analytical framework that had been prescribed by the Secretary of State himself. It's suggested that the statements in Parliament could be relied upon as evidence of the reasons. Of course, the point about the statements in Parliament is that they don't constitute an explanation of how these factors were weighed relative to each other and why they were regarded as sufficiently compelling to outweigh the promise that had been made, or the commitment that had been made, however it's expressed. It simply reflected the statement of an assortment of reasons why the Minister had decided to opt for the review. And of course, there was a greater obligation on the Secretary of State to explain exactly how all that came about in circumstances where, having performed the stated process, he'd come to the opposite conclusion. The reasons for that about turn, the reasons for not referring to the 6 factors aren't explained in the parliamentary statement, or either of the parliamentary statements. And of course, by not providing direct evidence in the form of affidavits, there was never any room for cross-examination of the Secretary of State in relation to any of these matters. So it said it's appropriate to have regard to the briefings as contributing to the elucidation of the reasoning. That is difficult to follow in circumstances where the consideration of the briefings led to the exclusion of the option that was eventually adopted. Again, there's reference to the full-blown analysis, which is irrelevant for the reasons that we have explained. The conclusion then is that all this material, these core briefings, can be relied upon to see how this material fed into the decision. It's not good enough to be shown a bundle of documents and say that they all feed in to the decision in some non-specific manner. What was required was the kind of public interest test identified explicitly by Mr. Threlfall, who said, you have to make this decision, you have to weigh up these factors, you have to explicitly address these factors. It could not have been clearer. When it was done, to some extent, we get one result. When it's not done, we get a different result. And that can never be regarded as getting past stage one, which is identifying the factors, let alone stage two, which is showing how those factors are sufficiently compelling to outweigh the promise. It was suggested that it was not therefore necessary to require ministers to swear affidavits in relation to this, and my learned friend rejected the notion of any requirement to that effect. Generally, of course, it's perfectly permissible for officials to explain the process of departmental decision making, but where the decision requires the kind of assessment to be made in person by the Secretary of State, nothing less will do than an explanation by the Secretary of State, especially bearing in mind the particular process that occurred here and the decisions that had been actually made by the Secretary of State here. A question arose, I think, from my Lady Black in relation to the transcripts in the De Silva report, the reference in the footnotes to the transcripts of evidence that apparently had been taken by Mr. De Silva. The question was whether or not they had ever been published. The short answer is no. There was never any publication of any of this material.
Would the materials have been made available to the DPP and the police, as far as you know? You don't know?
We just don't know.
Don't know. Right. Thank you.
I think it's unlikely, but I can't say. There's no information to that effect. All the police have investigated post De Silva is the new and significant information, in quotes, and it's possible that the transcripts could, in some cases, have come within that rubric, but we just don't know.
Yeah, thank you.
So it said at the end of all that this De Silva process was a critical examination of the documents and it was effective. Well, the hallmark of effectiveness is whether or not, and I don't want to anticipate what's said in relation to the Article 2 argument, which is a slightly different category here, but the hallmark of effectiveness is whether anyone was ever held accountable in any sense. In this case, Sir Desmond De Silva came to the conclusion that there were people in the Army and the police and the security service who were responsible for furthering and facilitating the murder of Patrick Finucane. No single person is identified in that report as being responsible to any degree for any of that. So when my learned friend says this review by Sir Desmond De Silva was effective, I have to ask the question, name one person who is held accountable for this facilitating and furthering of the murder of Patrick Finucane. And no one is. Just one minor technical point in relation to the De Silva inquiry. A query was raised by my Lord Kerr about the interview, the fact that there was no interview of the handler of Mr. Nelson, and it was indicated that there was some medical evidence about that. I think, strictly speaking, what was said was that there were medical reasons for the non-attendance or cooperation of the handler. It normally can be inferred that that means there must have been some sort of medical evidence supporting those reasons, but in fact I don't think it's indicated in terms that there was medical evidence supplied. Certainly we never saw or any medical evidence, or were told even the outline of any medical evidence, if there was any. It was just a general reference to medical reasons. We're not sure whether that was a long-term debilitating condition of a psychiatric nature or a physical nature or any detail whatsoever, or whether it could have been a short-term condition. But insofar as it's suggested that the report is living proof that compulsion is not required, we, not surprisingly, would suggest quite the opposite. Then my learned friend moved on to Article 2 and divided his submissions into 3 different areas. I'm not sure I need to deal with the first, the engagement of the obligation. I think I've already explained some detail or reasons why we indicate that the obligation is engaged. I think in relation to the second aspect of the matter, the compliance with the obligation. My learned friend, again skillfully, avoided dealing with the fact that the government did, in this case, decide to have an inquiry. That's in 2004. It's pre-McCaughey, but as a matter of law, with the benefit of McCaughey, we know that that meant that the government was obliged to conduct an inquiry that was compliant with Article 2. And McCaughey, of course, was actually handed down eventually before the decision was made not to have such an inquiry. But no attempt is made by my learned friend to address the consequences in Article 2 terms, in domestic law terms, of the state as an entity having made a decision to have an inquiry that, as a matter of domestic law, had to be compliant with Article 2. It seems to be assumed that in this context the government is entitled simply to reverse its decision, and that there are no consequences of having previously decided that an Article 2 compliant inquiry is required. Then questions were raised about the extent to which this Article 2 obligation was complied with by Stevens 3 and the DPP decision, and reliance is made on the Committee of Ministers decision. There are 2 different aspects of this, but if I can deal with them more or less together. It will be remembered that no one was identified in the Stevens report as being culpable in any way for what we now know to have been conduct that facilitated and furthered the murder of Mr. Finucane. And even the Secretary of State, in deciding to have a review, recognised that the truth hadn't emerged in this case, and that there was wrongdoing of a serious nature, but that there was no public account of that wrongdoing. Now, that's in circumstances where we've already had Stevens 3 and the DPP decision not to prosecute. So the Secretary of State, the government, the state, have acknowledged out of their own mouths that Stevens 3, even in combination with the DPP's decision, does not amount to compliance with Article 2 in the sense that it constitutes any kind of holding of anyone to account or identifying of anyone responsible or any kind of public account of the truth, assuming that the truth could be identified or established or ascertained from the material that was within its possession. I'll come back to the Committee of Ministers' assessment of this matter shortly. But taking the court through the submission made by my learned friend, he refers to Amin and L and said that the hallmark is of an Article 2 compliant inquiry is that it's effective. And in L is apparent by reference to the Ramsahai case. But what that means is that it has to be effective in the sense that it's capable of leading to the identification and punishment, if appropriate, of those responsible. The test, this comes from Ramsahai, paragraph 353 in particular, the test is whether the investigation secures accountability in practice. Nobody has seriously suggested that accountability has been secured in practice here. The Secretary of State, the Prime Minister, recognised that accountability in practice hadn't been secured because there was no truth in the public domain, that nothing had been revealed in the public domain that would allow the public to understand what had happened and what had gone wrong, how and why, in their terms. It was accepted that something had gone wrong, so the issue that Mr. Desmond de Silva was looking at was not whether something had gone wrong. We all know that something had gone wrong, but how and why it had gone wrong. So the state, through the Prime Minister and the Secretary of State, are recognising explicitly that there's been no accountability here. I mean, there hasn't even been a statement of what happened, let alone a statement of who's accountable for what happened. And that hadn't emerged from the Stevens investigation. Justice Corrie found evidence of collusion. Sir Desmond de Silva agreed. He agreed that there had been people in the security forces generally responsible for facilitating and furthering the murder. But no one's identified, still less held to account. So none of that could possibly be regarded as being effective within the meaning of Article 2, as determined in cases such as Ramsahai and indeed in domestic cases such as L. Then my friend turned to the Committee of Ministers and suggested that the Committee of Ministers has somehow determined that there's been compliance with Article 2. I think we indicated briefly in our primary submissions that betrayed, if I can say so respectfully, a failure to understand the nature of the decision-making process in Strasbourg and the extent of the decision-making process. The case of Geraldine Finucane against the United Kingdom is in Volume 1 of the Authorities. I'm sorry to take the court again to this briefly. Volume 1 of the Authorities, tab 5. The court will remember that at the time this decision was handed down by the European Court in July 2003, Stevens 3 had not finished. It was still ongoing. And there was a narrow submission that was being made in relation to Stevens 3. It was essentially that it could never be regarded as a prompt investigation because it was so long after the murder, and that it wasn't independent because Mr. Stevens, or Sir John possibly at that stage, had to report to the RUC Chief Constable. The court confined itself to finding, as appears from paragraph 80, MS 3099. Yes, 3099. That it confined itself to the conclusion that because this investigation took place some 10 years after the event, it cannot comply with the requirement that effective investigations be commenced promptly. And it said, in terms, the court does not find it necessary in the light of these defects to consider further allegations of lack of accessibility of the applicant to the procedure or lack of independence of the inquiry. So it decided the matter entirely on the basis of lack of promptitude. Left to one side the question of accessibility, lack of independence. Didn't examine the question of whether it was effective at all, because that wasn't an issue, because nobody knew what the result or outcome of the investigation was going to be at that stage. And it's against that narrow background that the committee came to consider compliance with the judgment, not the question whether the state, the UK, had complied with its Article 2 obligations in the case generally, but whether it had complied with the judgment. And it says the Secretariat, in its assessment, in terms at paragraphs, this is now at MS 1285, Appendix 3, hard copy 969, it's limiting its assessment to these two issues of access and lack of public scrutiny. That appears in paragraphs 135 to 138, proposes to look at whether the above those two elements, and those two elements only, have been satisfied in the subsequent procedures in the case, and decided that they had by virtue of the DPP's decision. That was it. That was the full extent of the Secretariat's assessment. The Secretariat was not saying, and therefore, Stevens 3 and the DPP and whatever else has happened since have constituted an effective investigation of this case so as to comply with Article 2. That's not what was being addressed. The Secretariat said nothing about the effectiveness of that investigation or the degree to which it complied with Article 2. And so against that background, with that recommendation, in those limited circumstances and that narrow ambit, that the Committee of Ministers came to its conclusion that the case should be closed. It was not a finding in any sense that the Article 2 obligations of the state had been met. And it clearly thought that there was an issue about that because it was strongly encouraging the UK authorities to conduct the public inquiry that the UK government was then in the course of arranging through the correspondence that's referred to in these papers. So there's no question of the Secretariat or the Committee of Ministers coming to the conclusion that Article 2 had been complied with and that Stevens had been effective in its own right, either singly or together with the DPP's decision. That's just completely wrong. And it's said then that alternatively, if the Secretary of State is not right in the submission that there's been compliance by virtue of Stevens and with the DPP's decision, the various other strands, including De Silva, in combination, are sufficient to comply. And these investigations into those directly responsible for the murder have been sufficient. This application, this case, is not just about those who were directly responsible for this murder. It's not even mainly about who pulled the trigger. This is mainly about who pulled the strings. Who in government, who in authority, who in the army, the police, the security service was responsible for pulling the strings of the puppets who pulled the triggers. And there is nothing in any of the material that has been assembled in the nearly 30 years since this murder which has held anyone to account, anyone in authority to account for what took place, the wrongdoing that's admitted to have taken place. And that is the reason, the primary reason why it cannot seriously be suggested that these investigations, cumulatively or otherwise, have been effective in Article 2 terms or any other terms. As for the Bracknell issue, it's suggested that the obligation, as far as there was an obligation arising from the new and significant evidence, has been satisfied because the police have looked at this material and decided that it's not sufficient to give rise to any new lines of inquiry or investigation. The court now has the affidavits of Mr. Murphy and the letter from Mr. Murphy, or the PSNI to us. The court will see that this tells us nothing about this material, which was supposed to throw a flood of light on Sir Desmond de Silva's investigation to such an extent that it was crucial in his investigation and allowed him to re-evaluate the evidence of others to such an extent he could set it aside. We have no idea what that information was because the police refused to say what it was. All they're saying, as appears from paragraph 3 of Superintendent Murphy's third affidavit, is that it didn't relate to individuals alleged to have had any direct role in Mr. Finucane's murder. It related to the security service propaganda initiatives described by De Silva in chapter 15 of his report. Now, we know from what's described in chapter 15 of the report that this was about the security service, MI5, taking steps deliberately and consciously to legitimise Mr. Finucane so that he could be killed by the loyalist paramilitary killers whom they were manipulating and resourcing in order to kill not just Republican activists, whether that be suspected IRA members or Republican Provisional Sinn Féin members, but the lawyers who acted on behalf of those individuals in court through lawful processes made available to guarantee the rule of law. They were doing that in circumstances whether or not in the judgment of the police this could amount to complicity in the eventual murder. That was the kind of wrongdoing and infringement of Article 2 rights for which the people responsible ought to be held account to some degree. And for that reason, this material should be disclosed. For that reason, and for all the other reasons that we have advanced before the court, this court should respond to the attack on its legal system, on our legal system, by requiring an inquiry in this case into the conduct that's recognised to have been a horror story, that's recognised to have been as bad as it gets and far worse than anything in Iran or Afghanistan or Iraq. If I could just have one moment, ladies. Unless there are any other matters which I can assist the court, those are our submissions.
I'm sorry to rise again. I wanted, if I may, my learned friend said in his reply that the police who were reviewing the De Silva report had only looked at the new and significant information which he's just been making submissions about. Can I simply give you two references which indicate that that is not an accurate portrayal of the evidence before this court? In the first affidavit of Mr. Detective Superintendent Murphy, paragraph 5, MS 574, making it clear that the police and the Chief Constable had asked the police to look at the entire report for further evidential opportunities and that part of that had been completed. And then paragraph 4 of his second affidavit, MS 582, to similar effect. The final report was not limited to a study of the text, but was informed and assisted by the process of reviewing materials which were seen and generated by the De Silva review team. So it's the whole report and the materials seen by them that was the subject of the police review. I'm sorry, I'm also very conscious, I meant to say at the end of my submissions, there are some queries from the, been some questions from the bench, and indeed my lady's question of about the derivation of the Inquiries Act and all of that. We're still looking. Can we put in something as short as humanly possible if we bump into anything of relevance?
And I wonder if you could answer the question which I asked Mr. MacDonald, but should have asked you, did the police get the transcripts of the interviews from...
I'll check that too.
Thank you.
Is there anything you want to come back on, Mr. MacDonald?
Madam.
No. Thank you. Well, thank you, everybody, for your very helpful and full submissions on this very anxious case. And, we will now go away and think about it as hard as we possibly can. Let you know our conclusions in due course. Court is now adjourned.